Welcome back, Law Venture. Ooh, that was a rough start, but we're going to push through. We're going to get this intro recorded. Welcome back, Law Venture. My name's Jarrett Stone, and if you're looking for an interview slash podcast slash video of a young lawyer defeating pretty significant odds stacked against him in order to have a pretty incredible result at trial, then you've come to the right place. In particular, I had the honor and the privilege of interviewing a plaintiff's lawyer named Brian Burkhardt. He's a lawyer out in Fort Worth, Texas, and whenever you can't find him in the courtroom, you can probably find him on national TV competing in America Ninja Warrior. He's the guy that has a shirt that says Law Ninja while also maintaining immaculate hair that doesn't move despite all the jumping and the hanging and all the craziness that he can do. Which reminds me that I need to go into the gym today. I decided that I needed to interview Brian because he ended up posting in our Law Venture community that's exclusively for plaintiff lawyers and hashtag free to join. And that post had all the details of his trial. And there were a couple things that stood out immediately to where I knew the verdict was something truly special. The first thing, he got a fantastic verdict in a very conservative county. The second thing, he had a client that is a motorcyclist and got injured while on a motorcycle, which frankly, oftentimes doesn't have a good result because people tend to be more inherently biased against motorcyclists. And the third, the defendant was the Texas Department of Transportation. Despite those three things, Brian ended up getting a verdict for his client in the amount of $638,336.50. I have no regrets about that one. Money. Look, I'm going to own up to the fact that if you tell me there's a motorcyclist against the Texas Department of Transportation and the case is in a very conservative county, I don't know if I'm taking that case. And the fact that Brian and his partner ended up turning that into a $638,000 plus verdict, bananas. But here is what blew my mind more than anything else. He didn't have a single doctor testify during the course of the 2.5-day trial. Here's what Brian has to say about that.
When we were going into this, we were thinking, why do we need to call the doctors? Why do we need to bring them in? We thought about having a deposition, and then we had some pause of thinking, their cross is going to come in, they're going to nitpick, or if you make the whole case about an objective finding, right? If you make the issue about he had this surgery, was it significantly exacerbated or was aggravated by this accident? Was it or was it not? And then you'll have a doctor that says, I think so, based on a reasonable degree of medical certainty, but I can't say for sure, but probably. And then they have a doctor that says, look, doctor, we need some certainty here. We got these folks down here in Tarrant County. We need to make sure what we're doing here. And then you have the battle of the experts. And then you got a plaintiff that says, no, it hurts. And then you got a lawyer who says, yeah, but you're old, sir. Come on. You got pain, you got aching. You want these people to give you $500,000 because you got a sore back? Wake up. That's the insinuation. And then you have the defendant here, TxDOT, that say, shucks, we're just doing the best we can with our tax dollars. We're living on a razor's edge here, doing the best we can. And you got a bunch of plaintiffs lawyers here to knock us around. That's just what we need. And so we wanted to avoid that framework that probably happens all the time. And we did that by making it not about, number one, not about the medical bills, which is easy to say, by the way, when you stipulate to them. So that's another caveat. We had the luxury of not battling about the bills because they were stipulated. Number two, you get into this mess about going through records. Sir, I want to direct you to page 17, and talk about this medical record, how that's affected your life. We got rid of that crap. I don't think we went through a single medical record, Jarrett. I don't think we went through a single medical record during trial. We referenced them. We referenced the procedure. I held up the binder. I don't have it with me, but I held up the binder in closing argument that was 500 pages and said, folks, Rusty's made himself bare before you guys. There's hardly any redactions. Go look through those medical records if you so should choose.
What Brian is doing is focusing on the power of perspective. Because who has better perspective on the plaintiff's struggles than the people that the plaintiff sees on a day-to-day basis, the close friends, family, and coworkers that all surround the plaintiff's life. So Brian talks about how he uses this power of perspective to also then transition into starting to justify his ultimate ask for damages.
A doctor sees them for 30 minutes. We got to remember this. The doctors see them what's on paper, on the chart. They have discussions with them about maybe an objective finding, and they cut them loose. And then you got a defense expert who's never even seen the plaintiff until the day of trial. And then you have the defense lawyer who met them for the first time in the deposition, for the second time at trial. These people are not credible, even the plaintiff's doctors. They are not credible to talk about the life experience holistically of what the plaintiff is going through. Who is the family, the wife, right? The guy who picks him up and takes him to his appointments, the person who's running with the trying to run a business with them, and now he's completely out of whack. And so that way the jury can understand, okay, little old Lisa, she was playing pickleball with our community in her 70s, but after the accident, she loves being with us, but she no longer plays pickleball. She sits on the sidelines, but she'll bring us cookies and flowers, and she's a wonderful woman, but this has definitely affected her life. And with that understanding, under the framework of Rick Friedman, I think this is David on damages, where he says some people may not care about planting flowers or dealing with pickleball, what you can and can't do, getting on a ladder. But when you take away someone's freedom in their golden years of retirement, that's worth something. Everybody can understand that. I've been working my whole life for retirement. No one's taking that away from me. And with our case, if it's one thing that conservatives dislike more, perhaps than doling out dollars historically, it's the government who misuses tax dollars. And so with that framework, people are going to be motivated to render a verdict. I think I said in the closing argument, the AG who made the argument, I know we're running, we'll see what we can do on time, but the AG said, I mentioned to the jury, I said, this AG came up from Austin over here to Tarrant County to try this case. He's got a long drive home, and this verdict will give him something to think about on his ride home. He didn't object to anything like that, but small things like that where the jury says, yeah, maybe a verdict does make our roads safer. I brought up earlier, he didn't make that argument about our tax dollars, but if he would have, say a verdict against TxDOT is a verdict against the taxpayers. If we let TxDOT off the hook, think about the damage that'll cause, the repercussions of not rendering a verdict. Who's going to bear those injuries? Other Rusty Smithsons, your sons.
Quick timeout. I have a confession to make before we continue this video. What you're watching right now is the redacted version of Brian's interview. His full interview is over an hour long, and there's a lot of secret sauce that was coming out that's going to benefit plaintiffs' lawyers. So you can watch that full interview over at the Law Venture community that's exclusively for plaintiffs' lawyers and is #free to join. And I'll provide a link to that community down below. But if you're not a plaintiff's lawyer, or if you don't like free things, then keep watching this video, because Brian's going to share his insights and some of his framework that led to the success. You just won't get the secret sauce stuff. So with all that said, what's important here is the concept of sharing verdict results. And Brian shares his thoughts on that.
Jarrett, how amazing this is, this community that you're starting here for many reasons. First is that these stories in the background you hear about, this small case, or this is a meds and a half case, right? Meds plus 20% nuisance value for the other side. And this platform allows all those rumors that are out there to start accumulating, for us to start working together and saying, these aren't one-offs, right? This isn't an exception that we've heard in Denton County or in Tarrant County or in Johnson County or wherever in Texas or whatever jurisdiction or state, because that's what Law Venture is about. It's a nationwide community of plaintiffs lawyers. And to have that experience and the platform to talk about these verdicts, it helps all of us get out of that mindset that you're exactly right, you're talking about, of a framework that's so powerful to the jurors that talk about, pain and suffering, all those intangibles. We don't really award those. Or maybe if somebody lost a leg, then maybe we'll talk about them. But everything else, show me the meds, right? Show me the past medical and I'll write you a check and let me get back to work, right? That's how the insurance side, the defense, the agents, that's how they're framing this to the juries, to the populace. And it actually is so well ingrained that it affects lawyers as well. And so we buy their own mess. And so hearing stories about this, again, on the Law Venture platform, helps us really reshape and refocus to follow in the footsteps of these great plaintiffs lawyers and to be successful. So
boil down, we need to stop relying on stereotypes and assumptions based on counties and jurisdictions. And instead, we need to refer to actual data points and actual results that lawyers are having. So if you want to share a win or a loss that you experienced going to trial, feel free to reach out to me. If you're in the community, slide in my DMs. If you're on Law Venture's website, there's a contact form if you go down below. Now, with all that said, let's start talking about the case that led to the $638,000 verdict. Here's the background.
So I'll share with you what I'd call the perspective of the defense, right? This is just the cold facts, how they're going to lay out well before we put the full story, the full narrative behind it. But essentially, it is a motorcycle accident that happened where our guy, who goes by the name of Rusty, was riding his motorcycle northwest here in Fort Worth. And he's on the loop and he's traveling on lane 4, the far right lane. And as he's trying to merge or change over to the third lane, so he's going to his left, he ends up feeling what he explains as a death wobble. Their expert is the Texas Department of Transportation, what they call a head shake. For about a half second is all he remembers, is feeling that shake or wobble, and then he immediately wakes up in the back of an ambulance, not knowing what happened, not knowing the cause of it, if his wheel was falling off the front, what was going on. Come to find out, there was a defect in the road, a varying gap at the very beginning, maybe a few inches, towards the middle, closer to 4 or 5 inches. And then at the very end of that uneven lane, there was actually a pretty big pothole. So it was a couple of defects actually working together to make this an impossible roadway to navigate for a motorcycle. And so that's the gist of it. There's no other vehicles involved. It was just Rusty and his motorcycle. And we'll flesh out some of the background as well, but that's just the basic there.
If we reverse engineer Brian's success, he has a great verdict that is coming from a great jury, which is going to require a fantastic panel during jury selection. So the question that I had for Brian, what was the hot topic during jury selection?
It came down to mental anguish.
Okay.
A lot of people had strong opinions. And I remember my original post, I think that I posted on the Law Venture community, that people, I said we had a couple of lightning rods. There were people that were very obvious about their, and credit to them, right? We want the panel to be honest, open and honest, and have that discussion. And a few of them had very strong opinions about mental anguish. And it's not necessarily that they can't award them or that they wouldn't award compensatory damages for non-economic damages, but it's the fact that some people have trouble dealing with, if it's difficult for me to quantify it, I'm not comfortable even stepping into that realm. And so for a lot of people, I mean, how can you put a dollar amount to, a paper cut on my finger? That's pain. But number one, are we going to compensate for that? And number two, if so, what is that worth? $9? I mean, if I get a paper cut that ruins my week, I'd pay $10 to get rid of that. For sure. $10 would make me whole. And so you take that to the very serious, by the way, I don't recommend doing that. People are going to think you're filing a lawsuit over a paper cut, but something to frame up for the jury, how I can quantify that. And it makes even more difficult of dealing with once you get 12 people back there. Good luck getting one person to figure out what compensatory damages is worth for impairment for past medical, or past physical pain and mental anguish. But you get 12 people back there, and it actually gets much more difficult to do. So we had probably a half dozen people who raised their hand and had issues. Kelly had plenty of grace with these individuals and communicating with them. How do you go about doing that? Could they keep an open mind? Which I've heard actually Nick Rowley a couple times also mention that. Maybe in a couple board hours I've seen from him. If you can't win the juror, right, and you know a peremptory is coming, maintain your credibility best you can with the remainder of the panel, and then ask them if you don't have the language where you think you're going to have them struck, try to extend an olive branch and just make everything easy. But everybody else said, yeah, no problem. If the evidence supports it, I got no problem giving compensatory damages. And then the people who said, no way, I'm not doing that. I'm sorry. I can't do it. And I think we should show some grace to people. And I don't know, I'm just not comfortable doing it. And those people got struck.
If mental anguish is the hot topic during jury selection, then my fear during closing argument would be asking for an amount or recovery under mental anguish that would be off-putting to the jury. Here's how Brian handled that.
I was walking through the pain, the past pain and the future pain, and I asked for 50 in past and 100 in future, and they gave us that. And then I told the jury, right in the middle of my close, I said, now for past mental anguish and future mental anguish, that's a difficult task for you guys to struggle with. There's no secret about that. But I trust that the 12 of you back there can make that right decision for Rusty. So I had a strong ask for the physical pain and future pain. And I gave them a number. I'm sure the white balance is going to flush this out, but I gave them a number. Yeah, not bad.
Yeah.
So when they're filling these out, they got 2 blanks here, and they got these 2 filled out. Okay, so they're looking at these 2 numbers for reference on these 2. Now, what's the likelihood if I'm asking for 50 or 100,000 in past pain, that they're going to offer 5,000 in mental anguish? Maybe. I've seen grossly disproportionate damage awards, but those folks are looking right out there and thinking, well, 50 in past pain. I don't know. What do y'all think? 50?
I'm going to go ahead and just say that this next part you're about to listen to is pretty crazy. If you told me going into this interview that Brian was going to say what he ended up saying, wouldn't believe you.
Right there in 113. And then for future meds, you got $100,000. Jared, I spent 0 time talking about future medical. 0 time talking about future medical.
Nice.
So I just left that to the jury. I said, look, there's between the 12 of you, you have his records. I'm going to leave that to you all, the future medical. I think I said there's one thing we can probably all agree on is that the number's not going to be 0. That's what I said. And if you push them off that cliff, you get them in the van, right? You get them, shove them in the van like the Japanese subways. You get them all in and close the door and try to get everybody to agree that it's not 0. Then it's something. Then it's something. And then just get them back there talking about what that number is going to be, whether there's a comma or not, but it's not 0. So that was kind of the methodology with the damages. In this case, we didn't use a per diem argument. That is $7. A tank of gas for Rusty when he filled up was $20, or they paid their expert $2.25 an hour. So if it's worth enough for the taxpayers for that, it's worth enough to make somebody whole. We didn't do that. We just sometimes it's difficult for people to give a number on damages, and so if they're looking for you as the moral guidance in the courtroom, they're looking for you to give that number, right? If again, this is one case, but when they're thinking, how do we give a number? I don't know what number we give, but I trust that young lawyer. I trust him on the facts of the case. Throughout the entire presentation, he seemed credible, and he said $50,000. I say we go with him. And that's all they have. They don't have Google. They don't have the other case or anything to compare this case to. I took an oath as the jury. I took an oath to render on the evidence, and Brian's presented a credible account of what happened. Guys, I say we just write it in.
So I'm not going to lie. One of the more difficult things to do with video and content like this is to end the interview or the video with a gold nugget to reward you for watching the full thing. So I'm going to go ahead and punt it. What I'm going to do is defer to Brian on this one.
Jared, thanks so much. I got to give credit to the law venture community and for you for making this platform that even, here on a Friday, just hanging out, talking about war stories and helping people not just talk about, certainly not to discredit Jerry Spence, but a lot of times when interviewers ask them about their experience, they say, to win the battle in the courtroom, you got to first win it in your own mind and in your own heart. It's like, absolutely. But brother, we want to hear about us. Like, tell us about the case. And you got these lawyers on the other side of the journey, like 20 plus years of experience. They say, you know what? The battle's really not in the witness stand or nothing. It's a week before trial, having dinner with your family or with their family, the plaintiff. And that is 100% true. But what's awesome about the law venture community is we get to kind of peel back the onion and see how exactly did you get that verdict? And I know this is small compared to the Mount Rushmore of people like Rick Friedman, and all the guys, Mark Lee. So just thanks for making this platform available for everybody. It's been a blast.